Okay, we are now going to talk about what is called circumstances affecting consensus. Circumstances affecting consensus. Okay, so when we talk about consensus, we are loosely referring to agreement within the context of something that's legally binding. Okay, it has been indicated that consensus is the basis for the validity of every contract, okay, which it constituted by a meeting of the minds of the contracting parties, okay. This approach is known as the intention theory or will theory or consensual theory, with consensus as the primary basis, okay, the primary basis for contractual liability. Therefore, if there are circumstances that affect consensus, the existence of the contract may also be affected. Depending on the circumstances affecting the consensus, in this case, the contract will be void. No valid contract therefore exists, or it will be voidable. Simply meaning a valid contract may be cancelled by the prejudiced party. Okay, right, so that has now been established. So let's continue. If the consent of one of the parties is legally invalid, an example would be one of the parties has been declared a prodigal and thus lacks the capacity to act, there can be no valid contract, okay? If consensus is absent for any reason, an example would be material mistakes, such as the contract is in principle void. In contrast, where there is a consensus which has been achieved in an improper manner, an example would be as a result of duress, misrepresentation, or undue influence, the contract is voidable. Okay, such contract is valid, but owing to the fact that the party's consent has been obtained in an improper manner, the injured or the prejudiced party has the choice of upholding the contract or cancelling it. Okay, right, in this case, let's look at what is referred to as mistake, otherwise known as an error. Okay, a mistake in the context of the law of contract carries a far more restricted meaning than in the everyday sense. Mistake in contract means that one or both of the parties have the incorrect impression, which in turn affect the validity of the contract between them. There are two possibilities with regards to mistake. Either the mistake is material due to the fact that the consensus was lacking. An example would be a contractor purchases a loader in terms of its installment sale transaction, whereas he was under the belief that the loader was purchased in terms of a lease agreement. So there's a difference between a sales agreement and a lease agreement. So that is what we call a mistake or an error. Alternatively, the mistake is not material due to the fact that it only affects the decision to contract. An example would be, let's say Steve is purchasing a vehicle from Joe, who he mistakenly believed was a prominent cricketer. As Steve visited the motor dealership to purchase the vehicle, his mistake did not influence his decision to purchase the vehicle. With the mistake, therefore, being non-material, okay, the fact that a mistake was material may lead to unjust results under certain circumstances due to the fact that a party may seek to rely on his own material misunderstanding in order to escape liability. Thus, our courts accept that parties will be held to their declarations of intentions unless circumstances are such that the mistake is deemed to be reasonable. We should see the doctrine of quasi-mutual assent, and then that will give us some deeper insight. Okay, right. Conventional approach to material and non-material mistakes. The South African law, in distinguishing between material and non-material mistakes, divides mistakes in contracts into various types. There is what we call error in negotiato. Okay, this is a mistake regarding the nature of the contract being entered into. An example would be Veronica intends to purchase, whereas Dana intends to let. This is error in negotiato. Okay, which is a mistake. Okay, the mistake is material. That essentially is what it means. Okay, now we have what we call error in corpore. Okay, this mistake regards the identity of the subject matter of the contract. Okay, this mistake regards the identity of the subject matter of the contract. Here's an example. Roger intends to construct a swimming pool for Claire, whilst Claire believes that Roger will construct a swimming pool as well as an external entertainment area for her. Which mistakes is material? In this case, the mistake is material. Okay, then we get what we call error in motive. This is a mistake regarding the reason for entering into the contract. A person's motive, or otherwise known as reason for concluding a contract, does not have any bearing on the obligations created under the contract and is therefore non-material. Okay, with consensus therefore absent. An example would be Patrick purchasing material for a nursery due to his mistaken belief that his wife was pregnant. Okay, and then here we also have what is called error in persona. This is a mistake regarding the identity of the other party. In most cases, such a mistake is material. In Porthia 1957, providing that the consideration of the person with whom I contract is an ingredient of the contract I intend to make. Thus, where Ellen books a struggling musician whom she mistakenly believes belongs to a successful band due to a strong likeness, Ellen's mistake is material. This must be contrasted with the purchase of the motor vehicle of Steve above, which was not material. Okay, then we have error in substantial. Okay, this is a mistake where it is regarded as an aspect, quality, or characteristic of the subject matter of the contract, which in general is non-material. For example, Bradley decides to purchase a house thinking that the famous actress previously lived there, which was not the case. Okay, the above list is not necessarily exhaustive, simply meaning it's indicative, it's an indicator, okay, of what these lists or these types of lists look like. Okay, it's indicative. Okay, what it noted that any error that excludes consensus is regarded as material. The purpose of classifying mistakes into different categories is to assist one with the determination of whether or not the parties were in agreement with the real question, always being whether there was consensus or dissensus. Now, let's talk about the mistake has to be reasonable. This is what we're going to talk about. The mistake has to be reasonable. Once the mistake is found to be material, the next question is whether the mistake is reasonable. A mistake that is not justifiable in the eyes of the law. An example, an unreasonable mistake will be enforced in accordance with the declarations of the parties of the contract, notwithstanding the fact that this differs from the party's real impression. A mistake is regarded as reasonable if the reasonable person, simply meaning the normal careful person, under similar circumstances would have made the same mistake. In the case of S versus Berger 1975, between brackets 4, South Africa 877, between brackets A, the court defines a reasonable person as follows. One does not expect of a reasonable person any extremes, such as the Solomonic wisdom, prophetic foresight, okay, Camelanaconic cautious, okay, headlong haste, nervous timidity, or the trained reflexes of a racing driver. In short, a reasonable person threads life's pathway with moderation and prudent common sense. Therefore, a mistake owing to the negligence of the person who wants to rely on it is normally not regarded as being reasonable, as the reasonable person is not negligent. Okay, right, mutual mistake, that's another topic to discuss, where both parties are at cross purposes due to the fact that each party has an incorrect impression which affects the validity of the contract. One has a situation of mutual mistake. Let's rephrase that. Where both parties are at cross purposes due to the fact that each party has an incorrect impression. Each party has an incorrect impression which affects the validity of the contract. One is a situation of what is called a mutual mistake, which intends to be tested against the doctrine of quasi-mutual assent. When we say quasi-mutual assent, we are referring to agreement, okay? Right. Should interpretation of what has been agreed be reasonable? Okay, should, let's say there's a party here, should party A, now should their interpretation of what has been agreed be reasonable, whereas party B's interpretation is not, then party A can rely on the doctrine whilst B cannot. Okay, if both parties, if the interpretation is reasonable, then the doctrine does not apply and the contract becomes void due to absence of consensus. Okay, rectification of a contract. Rectification of a contract. Okay, let's talk about that. Right. Should either party consider that a written document does not truly reflect the terms of agreement between the two parties to the contract, he may apply to a court to have the document rectified. It is noted that what is rectified is not the contract itself, okay, but the document in question, because it does not reflect the true intention of the parties. One needs to note that a void contract cannot be rectified by the court. Okay, and now we are going to talk about misrepresentation. Culpable misrepresentation, either fraudulent or negligent, is a wrongful statement of fact made by one party or his or her agent to the other party or his or her agent prior to finalizing the contract, which misrepresentation persuades the latter party to conclude the contract. The misrepresentation may be express or tacit, okay, simply meaning it may take place by means of conduct, and in some cases deliberate silence may amount to misrepresentation or mispresentation. Okay, innocent misrepresentation is a pre-contractual false statement of fact made innocently by one party and which induces the other party to enter into the contract or to agree to terms that he known the truth, okay, you would not have agreed to. Simply meaning if you knew the truth, you wouldn't have agreed to this, okay. One needs to remember that not all pre-contractual statements that turn out to be false are misrepresentations. Puffing consists in the praising or commending of the representer's performance and does not constitute a misrepresentation. An example would be a seller who describes his car as being in mint condition, okay, should be stated that the engine's compression ratio is as per specification, and this later is found to be false. Then his statement goes further than mere praise and as a result is wrongful. Should a misrepresentation have been made, then the contract is voidable. Okay, the prejudiced, deceived party has the choice either to upload the contract, to continue with it, or to rescind it, simply meaning to cancel it. This decision needs to be made within a reasonable time after the deceived party first becomes aware of the misrepresentation. Upon making the election, such election cannot be changed. Should the contract be cancelled, then each party is required to return the performance he or she has received. Okay, now in the case of culpable misrepresentation, the prejudiced party may further claim damage irrespective of whether the contract is upheld or cancelled. Damages is the monetary equivalent of the damage the aggrieved party has suffered, thus putting him or her in the financial position he or she would have been in had the misrepresentation not been made. Culpable misrepresentation is a particular form of delict, okay, which arises if the following requirements are present. Now this is important, because now we are going to quickly mention 5 points. Culpable misrepresentation of a particular form or delict which arises if the following requirements are present. Okay, 1, a false statement of fact made by the one party or their agent, by the other party or their agent. An example would be an act. Okay, number 2, wrongfulness. An example would be whether according to the legal convictions of the community the defendant has wrongfully infringed the interest of the plaintiff. This element is missing in the case of innocent misrepresentation. That's point 2. Okay, point 3, fault. Okay, an example would be the misrepresentation was either committed intentionally or negligently by the misrepresenter, simply meaning the party making the misrepresentation. Okay, then point number 4, the misrepresentation caused or induced the other party to conclude the contract or to agree to terms that he would otherwise not have agreed to. and this is point 5, the result of the misrepresentation is the conclusion of the contract or the suffering of patrimonial damage. Okay, so now what we are now going to talk about is something called duress. Duress arises when a prospective contractant is forced or compelled by means of an unlawful threat or intimidation by the other party or someone acting on his or her behalf, which causes fear, okay, in the prospective contractant, thus persuading the person to conclude the contract. Duress is a delict, and thus has the same requirements as misrepresentation. Due to the fact that the consent of one party is obtained in an improper manner, the contract is voidable at the option of the innocent party and not void ab initio. The contract is non-existent from the beginning, except where the duress takes some physical force. The aggrieved party has the choice of upholding or cancelling the contract. According to Christie, in 2001, it is necessary to prove the causal connection between the duress and the making of contract. Damages, if successfully proved, can be claimed. Okay, now we are going to talk about undue influence. Undue influence may be defined as improper or unfair conduct by one of the contracting parties by means of which the other contracting party agrees to conclude a contract with the former contrary to the latter's independent will. A party who alleges that he or she has been persuaded through undue influence to enter into a contract needs to prove that the following elements were present in order to succeed with the claim. Now there's only 3 points here, nah? That a relationship or trust existed between the parties concerned, such a relationship between an attorney and client, or doctor and patient, religious advisor and disciple, or husband and wife. Okay, and then 2, that the influence weakened that person's power of resistance and made his or her will pliable. And then number 3, that the other party used this influence in an unconscionable manner to persuade the victim to consent to a transaction that was to his or her detriment and that he or she would not normally have entered into when acting with his or her independent free will. For example, where an adult child tells his elderly mother that he will prevent her from having access to her friends unless she donates her property to him. Okay, now let's continue. Undue influence may be treated as a form of delict with the same requirement as misrepresentation. A contract concluded as a result of undue influence is voidable, and the victim of the of this arrangement has the choice of abiding by the contract or cancelling it. Okay, a claim for damages based on undue influence has not yet been considered by our courts. With it submitted, an actual patrimonial loss will need to be proven for such a claim to succeed.